All right, so what is happening with regards to surveillance videos?
So yes, in reference to that, my client did notify me that he's been trying to send me them. He believed that they have gone through, but it seems the file is not supported. That he's trying to send to my email. So what I can go ahead and do, Judge, is do an investigative request from my investigator to get these videos from him so that I can review before hopeful next court setting. And then I know that the state also did look into a body cam for the person on scene, and it seems like it was a Medina County Reserve officer that was working security there. So she went ahead, Lauren, and reached out to see if he had any body worn cameras as well.
Okay. All right, Ms. Ferguson, this will be the final date for discovery. If you can give me 30 days, is that enough time for both parties?
Yes, Your Honor.
For a final discovery date? All right, January 15th.
Yes,
Once you sign the reset form, you're excused.
thank you.
All right, thank you. All right, who else is ready?
PTD is usually a pretrial diversion style program, basically a structured earn your dismissal track. It's not a free pass. It's do everything exactly right or you're back in court. And the judge's tone here is telling, supportive but zero patience if someone treats it casually.
Cassandra Garza?
Here, Your Honor.
All right, so good morning. So how's PTD going?
It's good, Your Honor. We've been accepted. I have the stamped copy that has been received by the DA's office.
Okay, awesome.
We're in the program, we've accepted the contract, we've signed it and turned it in.
All right, just make sure you follow through on everything, all right?
Yes.
Ms. Ferguson, I need a PTD date, please. All right, January 15th. Once you sign the reset form, you are excused. And counsel, if she has completed everything and I receive the dismissal, then I will have signed it before that date. But if not, she'll need to appear.
Yes, Your Honor.
All right, thank you. Just have a seat. Your attorney will bring your reset form. All right, who's next?
Immigration consequences can be more serious than the criminal punishment. That's why you're seeing the judge pause, confirm language needs, and pull an interpreter. If you've ever wondered why some cases take longer, it's because one plea can trigger deportation, denial of re-entry, or future status issues.
David Cortez Jimenez. All right, today is the plea deadline date.
Judge, my client requesting the court for more time. He hasn't talked to immigration. He's not a U.S. citizen. He's worried about being deported.
Now, this is being set for a jury trial. Norma, set this for a jury trial. I'm sorry, are you a Spanish speaker?
Yes.
Are you able to understand everything that I'm saying?
I understand a little bit, but
Well, Norma, have an interpreter come down. Just have a seat. Time when the interpreter's here, we'll bring you up. And Norma, I'm gonna need a jury trial date for the first week in January.
Thank you.
Because this case has been going on since August. Not letting people put off for tomorrow what can be done today.
No, I learned.
I'm sorry, if you could cite just a second. All right, Norma. Mr. Kasmeric case has been resolved and there's no need to have him transferred from Nueces County. You're welcome. All right, and Henry Salazar. All right, why were you late for court?
Having trouble with parking and then long line outside.
All right, so here's the thing, you need to adjust for those in timing, all right? But thank you for dressing appropriately for court. All right, State, were you able to amend the MTR?
I think we are working on the amendment for the MTR, Judge. Additionally, defense counsel brought it to our attention that Mr. Salazar has retained counsel. So we can.
All right, who's the retained counsel?
Your Honor, that's going to be Mr. Mark Hull, and then I think that there's a Hillary
All right, so,
Crossup is supposed to be appearing for them today.
all right, so just have a seat. You need to call and tell your other attorneys to appear. All right, thank you. Thank you.
Can I make two, Your Honor?
Yes.
Thank you.
Shakira Laraga, sorry. All right, so in this case, has the evaluation been completed
It has been, Your Honor.
and the results?
She was found confident and sane at the time of the offense.
Okay. And you had the hearing in Magistrate's
Magistrate
Court?
court, yes.
All right, thank you. All right, so then today is plea deadline date.
Yes, we have received a new offer. There's some missing discovery that Ms. Galloway is going to look into. Uh, And I do need some more time. The discovery is somewhat voluminous, so I need to go over that with.
All right, and what discovery is missing?
There's a body cam where the officer's approaching the vehicle. It's the first officer to approach. So we have
Mhm.
other body cams, but not that body cam.
Okay,
That's kind of an important body cam.
and is that the only missing discovery?
And to our knowledge, yes, but it is somewhat voluminous.
All right, Norma, can you recall this for final plea deadline date on that first week in January, Thursday? All right, so we will be back on the 8th. Once you sign the reset form, you're excused.
Thank you.
You're welcome. Thank you for dressing appropriately for court. All right, Mr. Cortez. All right, your case has been in this court. It's an old case. I believe it must have been transferred here because it has a 2019 indictment date. But your case has been in this court since August of 2025. Your jury trial date is going to be January 6, 2026. You will be going to trial on that date. Do you understand?
Yes, Your Honor.
All right. And defense, before you leave, I need you to sign a discovery acknowledgement state on Cortez 2019 CR 6016. He's on page 11.
Yes, ma'am.
And it's David Cortez Jimenez. I need an acknowledgement of discovery filed in some.
Okay.
All right, and Ms. Ferguson, if you'll give him his reset form. Do you have any questions?
No, sir.
No, Your Honor.
All right, thank you. Rogelio Ibarra. Hello,
Hey, Judge, good morning.
good morning. All right, so where are we? I think you wanted some drug testing.
Well, there's some,
Data?
there was lab stuff that we had been requesting.
Mhm.
We technically have not received that. However, I've been in communication with Mrs. Galloway. And I think we're close to working this case out. She does need to verify some information that I provided to her. And I think after that, I think we may have an agreement.
Okay, and how old are you, sir?
I'm 18 now.
All right, Ms. Ferguson, I need a date for disposition the third week in January. All right, we'll be back on January 22nd. On that date, this case is either going to be resolved by agreement or either it's going to be jury trial.
Just Judge.
All right, thank you. And once you sign the reset form, you're excused. All right, Valena Page.
Plea deadline expired is courtroom speak for you had your chance to negotiate, now the court's calendar takes priority. It's a retention moment because you can feel the leverage shift. Prosecutors often have less incentive to sweeten offers once trial is set.
All right, so today is supposed to be plea deadline date? And,
We have an agreement, Judge. We just gotta.
all right, Ms. Ferguson, I need a jury trial date. How long do y'all expect this will last? All right, 3 days. So your plea deadline date has expired. The court will not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. Do you understand? All right. All right, can you do it earlier in March or that's the only thing that's available? All right, we'll bring you back on March 10th. That will be your jury trial date. And I need an acknowledgement of discovery.
Yes, Your Honor.
That's spring break, not available that week.
All right, the week after March 10th. Or either the end of February.
Okay. Thank
What,
you.
February 24th?
Yes.
Hey, Black History Month, I'll be here. All right, February 24th will be your jury trial date. Hi, you have Mertens?
Thank you, Judge.
All right. So do you have the discovery now?
I do need to go through it, Judge. It's about a terabyte worth of evidence, and I need to go through to make sure that is all the evidence. We did receive our first offer today,
Okay.
and so I've reviewed that with them, and we need to go through the evidence and consider that offer.
All right, Ms. Ferguson, set this for a plea deadline date at the end of January.
Fine.
All right, so January 26th will be your plea deadline date. At that time, you need to let me know whether or not you've reached an agreement with the state. If you have not, your next court date will be a jury trial setting. and the court will not consider any plea bargain agreements without good cause, or you have to plead open to the court after that time. Do you understand? All right, how old are you? All right. Do you have any questions about anything?
Are you like fire rejection?
Oh, your attorney will have to file something and then the court will consider it. And counsel, he says he's 18. Do you need longer than that date to go over things with him? I just find that young people, sometimes they don't understand the consequences
We have gone through the initial.
or internalize everything, I should say. All right, then that will be your plea deadline date.
Okay, Judge.
I wonder what that.
Oh, thank you. You too. And counsel, if you want to file motions and have them heard, you can. And counsel, on that case, if you could do the acknowledgement of discovery, please. State there needs to be an acknowledgement of discovery on Mertens.
Yes.
All right, the parties on Manuel Moses Ramirez. And are there applications?
No, Your Honor.
All right, probation, there are no applications. Court is calling 2025 CR 013930, State versus Manuel Moses Ramirez. Could I have parties announced for the record?
Lauren Espinoza for the state.
Sean Sheffield for defendant. We're ready, Your Honor.
All right. And are you Mr. Ramirez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. All right, I'm trying to find your true bill of indictment. Yeah, it's not here. All right, thank you. Oh, no, found it. It was stuck to another document. All right, Mr. Ramirez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did, ma'am.
Your client needs to sign that.
Oh, I'm sorry.
No problem. All right, your charge of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes,
And did you intend to give up those rights and enter into a plea in this case?
yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Ramirez, has anyone threatened you,
No.
coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand
I
it?
did, ma'am.
According to the plea, punishment is to be assessed at 12 months in the state jail facility. There's $1,000 fine and no applications. Did you understand that to be the plea?
No.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both
I
places?
did.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such
No,
motions?
Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? Guilty,
Guilty.
not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor. State offer States Exhibit 1 and all attached with.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Sure did, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront Any witnesses the state would call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
No.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We'd ask you, so, yeah.
Anything you wish to say on behalf of your client?
Judge, we just asked the court to follow the recommendation.
All right, the court will sentence you to 12 months in the state jail facility, give you credit for any time served. There's a $1,000 fine, time and money to run concurrently, and I'll suggest the therapeutic community for you.
Thank you, Judge.
The therapeutic community doesn't increase the time that you're in custody. It's just to help you with your sobriety. I do not have the authority to force them to place you in the program or order them to place you in the program. They'll just see on the judgment that I'm recommending that for you. When you get to the state jail facility, you'll have to request it as well. Do you understand?
Yes, ma'am.
All right.
Thank you.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess. You're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, I do.
All right, we can go off the record. Here's the thing. How old are you?
I'm 41.
All right, you're 41. If you continue on the path that you're on, only 1 or 2 things are going to happen. Either you're going to end up being in prison or the Bexar County Jail or somebody's jail for the rest of your life, or either you're going to end up using, and the last time you use may be the last time you use, because you never know if you're going to overdose, if somebody didn't make it correctly or what. You understand? Because the people who are selling that, they're usually not concerned about the person, because otherwise maybe they wouldn't be doing it. It's usually selfish reasons, all right? When you're released from custody, if you can't find a place that can help you with your sobriety, you come back here, I'll pick up the phone and I'll see if I can find transitional housing for you.
I appreciate it.
And in that police report, I saw that you were with someone. You can't help somebody until you help yourself.
Right.
So if they're using, it's not good for you to be around them because they're going to feed into your use. All right?
Yes.
All right. Good luck to you. Thank you,
Thank you.
counsel. Oh, Israel Gonzalez. All right. And this is family violence and criminal trial division.
Yes.
So the state was to make a global offer. Has that been done?
No, Your Honor. We're here for the discovery today
All
on
right.
the robbery because the other one, the one that deals with family violence has not been indicted.
All right. Family violence, if you'll come forward.
And I've spoken to the state, but they seem want on the criminal side defense of it.
So this is
This is a robbery.
Gonzalez, Israel Gonzalez. It's 2025 PF 20635. And so today it was supposed to be a global offer that is made. And are you on the PF case?
Yes, sir.
All right. So where are we on discovery on the PF case?
I've been getting discovery, but I get this new discovery as once it reaches the point where it's going to be indicted, it keeps them in discovery. But I've gotten some discovery on it, and the discovery that I did really recently viewed entirely was on the robbery, which is the same situation or the same complainant. Okay, now that's the one I received a whole slew of evidence and on that, on videos and discovery. There is one thing that I believe it's not in there that I didn't see was any phone records connecting my client with the complainant.
All right. So,
and just to have you know, Your Honor, this should probably be a trial.
okay. So what is outstanding? Is there anything outstanding on the assault peace officer or the robbery case?
I told Miss Carrillo that I need more time to look because there were people ahead of her,
Yeah.
my staff,
Yeah.
and I've not had an opportunity to look and see if what she's asking for has the contour.
All right, so let's step back and the state will review and then I'll call you back.
Okay, Your Honor, I gotta be in two, can we come back tomorrow? Because I have a motion to amend his GPS. Okay,
No, because we're in trial, so I'll just confer with the state and then I'll take
All
this
right,
matter. All
okay.
right, thank you.
to take that up, when you take up the motion?
You'll need to speak with the state and see if they're ready to proceed on your motion.
Okay,
Thank you. Who's here on Angel, Joe, Ojoel, Varela? And are you all ready to proceed on the motion?
Yes, Your Honor.
All right. Probation, this is a motion to revoke.
Good morning, Your Honor.
Good morning. All right, the court is calling 2019 CR 7765 State versus Angel Joel Varela. Varela, could I have parties announced for the record?
Ashley Jones for the state. Here at court before, Mr. Varela, Your Honor.
And are you Mr. Varela?
Yes, Your Honor.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? And did you understand it?
Yes, Your Honor.
Are you the same Angel Joel Varela who's placed on deferred adjudication in 2019 CR 7765 for the offense of burglary of a habitation with intent to commit assault on June 13, 2022 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. We are going to go forward on violation of condition number 1 from the supplement on first amended, motion to revoke. That is on or about the 17th day of March, 2024 in Yuma County,
Oh,
Arizona.
I'm so sorry. I don't have the supplemental.
Uh-huh.
All right, did you review the supplemental motion to enter adjudication of guilt and revoke community supervision with your attorney as well?
That's the one I signed, correct?
No. It's telling you.
Oh, yes, yes, Your Honor.
All right, the supplemental motion is telling you what allegations the state is saying that you committed that are a violation of your probation. Do you understand?
Yes, Your Honor.
And did you review the supplemental with your attorney as well?
Yes, Your Honor.
All right, they're just gonna get that for me because I don't have it. All right, thank you. Sometimes it gets lost in the system. Thank you. All right, state, you may proceed. Oh, it's still the First Amendment. I thought you said supplemental.
No, for, I corrected first amended, Your Honor.
Then I have that. All right, let's proceed.
All right, on or about the 17th day of March, 2024 in Yuma County, Arizona, the defendant Angel Joel Varela committed the offense of aggravated driving under the influence in violation of condition number 1.
How do you plead to that, true or not true?
True, Your Honor.
And the state will waive the remaining violations, Your Honor.
Any objections to the state's waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. The proposed agreement is that the court grant the the state's motion to enter adjudication of guilt, revoke the community supervision, and sentence the defendant to 3 years in the Texas Department of Corrections.
All right. Is that what you're requesting, counsel?
It is, Your Honor.
All right. Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right. And can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand, state your name for the record.
Angel Joel Varela.
All right. What have you completed on probation?
Well, Your Honor, on probation, I was going to work, being a law-abiding citizen, just trying to do my best to stay out of the way. Or be a good father to my kids. And really just my cousin, he passed away. I was really close to him.
Just stop in real quick.
Yes.
While I'm thinking of this, when we signed the paperwork, I told him he did have a limited right to an appeal, and you did ask him if he was waiving his right to appeal. So can I just explain to him what that means?
Sure.
Okay.
All right. So what have you completed?
having a job and being there for my kids.
I mean, everybody does that.
While I was in prison, I completed anger management classes. I completed a cognitive behavior classes.
So you've been sentenced on the other cases?
Judge, he was sentenced to up to 2.5 years in Yuma, Arizona. I believe he did a year and a half. If I'm reading the
Do
judgment,
you know that cause number?
yes. You ready?
Yes.
It's number S1400CR 2024000523.
All right. So you completed cognitive and that was while you were in custody?
It was just anger management
Cognitive anger management, that's another one.
and behavior analysis.
And that was while you were in custody?
Yes.
And that happened while he's on probation.
Okay. All right. This is what the court will do. The court is finding violation of condition number 1 true, and that's the violation with regards to aggravated driving. The court will grant the state's motion, revoke, sentence you to 3 years in the prison. This will run concurrently with S1400. Did you say CR?
Yes, Your Honor.
CR 2024000523. There's an affirmative finding of family violence. There's to be no contact with Liliana Martinez. There's to be no unsupervised contact with minors. There is a $1,500 fine. Time and money will run concurrently. And according to your plea bargain agreement, there's no outstanding restitution. Is there anything else with regards to sentencing?
Not from the state.
Judge, it's just, he wants me to make sure he's getting his back time for all the time he did Bear County, which I know I think he's entitled to, right?
Yes.
And then you're giving him his credit for the time that he served on this case in Yuma?
Yes, and it's running concurrently. And legally, I must give you credit for any time served.
Okay.
So that's, sometimes I don't say it because it's automatic and your attorney knows that it's automatic. But sometimes we forget that people who are not in the legal field don't know. So the record is clear. You're entitled to credit for any time served that you were in custody on this case. And you're entitled for any credit for any time that you were in custody out of state, as long as this warrant was pending. So if there was not a warrant pending and you were doing time somewhere else, then you're not entitled to that credit. Once a motion to revoke was filed on this case, then you're entitled to credit from that point. And your attorney will check to make sure that that is accurate.
The judge is reframing restitution like an emergency because for an 80-year-old on a fixed income, losing $12,000 is an emergency. And notice the courtroom psychology. The judge isn't just asking, can you pay? She's demanding a timeline and accountability.
All right. And if for some reason you go to prison and you find that it's not accurate, what will usually happen is we will receive a letter, it will be reviewed. And usually if everything is correct, what you're saying, someone will double check it. And then when they double check it, I'll sign a motion or an order granting you any time that you feel that's appropriate. You understand?
Yes, Your Honor.
And that's proven to be appropriate. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go with the record. Do better. Otherwise, you're going to find yourself living your life in somebody's prison or somebody's jail. You understand?
Yes, Your Honor.
All right, good luck.
Thank you.
You're
Merry
welcome.
Christmas.
Judge.
Thank you. Thank you.
Appreciate it.
Anaya Gifford.
Yes, Judge.
All right, the court is calling 2023 CR 5888 State versus Anaya Gifford. Can I have parties announced for the record for the state?
Megan Galloway for the state.
For the
Robert Bauer
defense?
for defendant, Your Honor.
And are you Ms. Gifford? All right, you entered a plea of guilty on October 16th. There was a request for a PSI. And according to your plea bargaining agreement, punishments be assessed at a cap of 8 years in the prison. There's a $1,000 fine. The state is opposed to your application. And there's restitution of $12,000 to Mr. Holtzworth. Have both parties had a chance to review the PSI?
Yes, I've reviewed it, Your Honor, and I have no objections.
I don't have any objections, Judge.
All right, and are there any witnesses?
The state has no witnesses, Your Honor.
No, Judge, I just have argument.
All right, the court will hear argument. State you're opposed.
I am, Your Honor. I'm asking for the court to deny the application and sentence her to 8 years, reserve the rest of my time.
All right, just one moment. All right, you may proceed.
So, Judge, I want to point out, from looking at this, Ms. Gifford was sentenced to a federal prison for I guess, a conspiracy charge that I think this case arose out of. She was released, I think, actually with a warrant in place from the federal penitentiary, and then made bond here. And I don't know why this was not included originally with the federal prosecution, or if in fact, I don't have a copy of the federal PSI, and I can't really determine whether or not the complainant in this one is actually a complainant involved on the federal case. And if the court notes, there's a restitution amount among all the people who were sentenced of $1,235,000. Ms. Gifford's currently paying restitution to federal supervised release, which is the federal equivalent of parole for this the federal charges. And she's employed now. She lives in Georgia, and I guess is capable of paying restitution on this case. If the court grants her deferred, obviously it would have been better for her if this case had been included in the federal sentence. And I think how much
I got sentenced to 57 months and I served 30 months.
so if the court doesn't grant her application, I ask the court to give her credit for the time she spent in the federal penitentiary, since this is in fact, I think, out of the same fact pattern, and I think the same conspiracy. But I would ask that she's been released and she's paying restitution now, that the court grant her probation and just let her pay restitution on this case as well. Like I said, I have no way of determining what restitution was ordered. I would assume it's jointly and severally among the conspirators, but I don't know if the complainant in question on this case was one of the complainants on the federal case.
All right, and my understanding in this case, and correct me if I'm wrong, I'm going from memory. This is a case where the complainant was told that their grandson was
That's correct.
in
That's right.
dire straits and that they needed someone to take their money. I'm sorry, they needed someone to withdraw money to save him from the dire straits that he was in.
That's correct, Your Honor.
All right. All right, state.
Judge, so what Mr. Mauer represented to the court is correct. There was a federal prosecution.
Excuse me just a second. All right, I can see you're pregnant, so there's no need to
I'm not trying to show
Okay.
that off. I
all right,
apologize.
thank you. You may continue.
There was a federal prosecution that occurred out of San Diego. And the court is aware of the $1 million restitution that they were ordered to pay out of San Diego. I didn't have anything to indicate that this victim was included in that. However, this was a very big conspiracy that they put together where they were targeting elderly individuals. The victim in this case is 80 years old and was targeted because of that. Called and told that his grandson was in danger and that he needed to spend $12,000 immediately to provide safety to his grandson. And the $12,000 is agreed upon. The evidence did point back that it did go into this defendant's Chase bank account. And in the stipulated evidence, the records, the Chase bank records are in there where the account is belonging to Anijah Gifford, Your Honor. And so we would ask that you order the restitution if you do give her community supervision, but I just don't believe that she's a good candidate for community supervision. So we would ask that you deny the application.
All right. I'm not saying I'm going to deny it or grant it, but when are you going to have this $12,000?
If I'm being honest, I can't give a specific date, but I can make payments, whatever you order. If you order for me to make a specific payment, I can work on that.
All right, here's my question. Do you have any loved ones?
Yes.
Mom, dad? All right, let's assume that someone's picking up the phone and calling you and saying, hey, your mom has been in this accident and we're going to arrest her unless $12,000 is paid, right? So look at that as that type of urgency. So when are you going to have this 12,000? Because I can tell you, and your attorney can probably tell you, the person who's 80 years old and you scammed them out of $12,000, they're probably on a fixed income. They worked all their life to save that, and you came in because you didn't want to get a job and you wanted to build your happiness off somebody else's misery. So I want to know when you're going to have this $12,000, and I can tell you the latest is going to be in February.
I can do that.
I think that's a good idea, Judge.
All right. And I'm not saying I'm going to grant it, but what I'm saying, that would probably help your case tremendously because he needs his $12,000. So, Ms. Ferguson, recall this for sentencing in February, and you need to have the $12,000 and you need to be here in court.
I will be here.
All right.
I'll get her to sign a reset form.
All right. Thank you. We'll see you back on February 2nd. At that time, you need to come with $12,000. And state, does that need to be in cashier's check, money order?
Yeah, usually there's an upfront restitution form we have to fill out.
I can do that.
All right.
Yes, ma'am. Thank you.
You're welcome.